Our hearings are now in person at Ben Franklin Place, 101 Centerpoint Drive. We also enable remote participation by video conferencing for our registered speakers. We are live streaming on YouTube, and the video will be archived and available for future viewing by the public. My name is Bill Hunter. I'll be chairing today's hearings, and you can address me by my name or as chair. With me are panel members. On my left, Terry Otto, and on my right, Martin Vervoort. The procedure will be as follows. Listed on the agenda and appearing on screen from time to time are the applications we'll hear today. For the sake of efficiency, I may deal with agenda items in a different order. Panel members have reviewed the planning reports and any written submissions in support or in opposition to each of the applications. Today, we'll hear any oral submissions relating to the applications. As part of the statutory public notification requirements, each applicant was required to post a sign on the property in question before the hearing. They also had to confirm in writing that they did so, or they need to swear or affirm an oath today that they've fulfilled the sign posting requirements. Otherwise, we may have to adjourn or postpone the hearing. The panel may ask for a brief presentation of any application, followed by questions for the applicant and city planning staff. We will then hear from members of the public who have registered to speak, and we may also have questions for them. Finally, the applicant, who has the burden of proof, will have an opportunity to make final comments in reply. Please address your comments to me as the chair, starting with your name and spelling when necessary and your municipal address for the record. All presentations are limited to 5 minutes. Any exceptions will be at my discretion. At the end of the hearing, the panel may either make an oral decision or we may reserve our decision, which means it won't be delivered today. In either case, and within 10 days, the Committee of Adjustment will send the official written decision and reasons for it to all the parties, participants, and anyone else who has requested a copy. Does anyone have any questions about the procedure we will be following today? Okay, we have several applications to hear today, but first we need to deal with some preliminary and procedural matters. Are there any declarations of interest?
I'm declaring interest on agenda items number 4 and 5.
Are there any other declarations of interest? No. Confirmation of minutes of previous hearings. Are the previous minutes confirmed?
Mr. Chair, I don't believe there are any minutes tabled for confirmation.
Okay, thank you. Withdrawal or adjournment requests. The committee has received a request to adjourn, actually from planning, which means to postpone to a different day the hearing for item number 1. Are there any other requests or questions about the procedure on the agenda today? Okay, turning to the applications that are before us today, we'll first deal with some unopposed applications that are straightforward and recommended for quick approval if there are no objections. Let's look at item number 1, French Hill Road. And as you can see, Planning Department has asked that this matter be adjourned pending a correction in the OP where apparently there was an error. And yes, sir, could I have your name, please?
Mr. Chair, Dwight Johnson, 4360 Piperville Road. I'm here representing the owner.
Yes, okay.
As to the adjournment, Mr. Chair, I would like to proceed today if we could. I don't see that that adjourning is going to make a difference in the outcome of the file.
Okay. Any questions, members of the panel, for this gentleman? Planning staff, any submissions, comments, questions?
Thank you, Chair. Through you, this is the same error that we've been dealing with for the past few months. Their previous panel members will be aware of it. There's this error in the severance policies for the official plan. And there will be an OPA coming forward to correct this error. However, in the past, the committee has chosen to hear these applications, but it's up to the committee whether we hear it or not.
So in the past, as I understand it, we've decided to proceed, not adjourn, subject to the change in the OP. Is that correct?
That's correct.
Okay. Members of the committee, what are your thoughts on that? Are we all right? Okay with that? Okay, we can proceed. Okay, are there any other comments from planning with regard to any matter? Okay, Mr. Johnson, would you like to comment?
Yes, I would, sir. Mr. Chair, members, we've done a fair bit of pre-consultation on this file. We've gone away and produced an EIS, and we've drilled a well and created a Hydro G report, a favorable one. These have been submitted to planning 6 weeks ago. In reviewing planning's comments, I have a couple of comments and questions, if I may.
Yes, you may.
They would like the EIS updated with a couple of items, and I agree with that. One of the items is to show a development envelope of 0.2 hectares. I would like to work with staff to come up with something a little larger than 0.2 hectares. The site is 21 hectares in size. The owner wants to put a house on the site, and down the road he wants to add a large shed. This is a very large country property out in Cumberland, and 0.2 hectares is quite restrictive. The front area of this property where the house is going to go is about 1.4 hectares, and I would like to propose and work with staff, of course, to come up with something a little larger than the 0.2 hectare envelope. And I just wanted staff's comment on that.
Okay. Have you any other comments,
Yeah.
Mr. Johnson?
Yes, I do. Yes, I do. Again, within the comments, we have been requested to do a level 1 ESA. There's evidence that there was a dump of some sort across the street down the road a ways. And I'm just questioning the need to do that. We've, the house that's on site now was built in 2011. No issues and no discussion of an ESA at that time. We just completed our Hydro G study. We're not seeing any evidence of any problems. And so again, with staff, I would just like to question the need for that. And then lastly, suggested number 8, it was suggested that, we had to look at limiting distance to the west property line for the existing buildings. And again, I question the need to do that. The existing buildings we have a shed that's 20 meters from that property line, and we have a house that's in excess of 30 meters from that property line. So, we're talking a very large rural property here, and I'm just wondering the need, to go ahead and do that. So those are my comments.
Okay, thank you, Mr. Johnson. Planning comments, please.
Thank you, Chair. In regards to the EIS, the development envelope, the 0.2 hectare area is something, a relatively standard request that our environmental planning staff ask for on these rural severance when there are natural features involved. We could be able to work through a compromise to allow for a larger envelope, and that would be through the review of the EIS with the environmental planning staff. As for the ESA, that was requested by our engineering department. The site to the north did have a previous landfill. So the phase 1 ESA is requested to ensure that the site is safe to proceed with. And the last comment was about the building code regulations with regards to the limiting distance to the adjacent buildings. That condition was requested by building code services. As such, I would not be comfortable compromising on that without their input, and they're not available at this moment.
Now, if there's a meeting with planning staff, for instance, on the 0.2 hectares, then that would have to be resolved before this can be approved today.
So for the EIS, we've requested that an amended EIS be submitted as a condition of approval. So that could happen after a decision today. The final condition regarding to the building code would need to be satisfied as a condition of approval. And that would be up to the building code department whether it's satisfied or not. So perhaps they would be able to compromise as well, but the condition states that they need to submit a drawing showing that the distances are sufficient.
And if the applicant talks to the building code people and they agree on a change, then what happens as far as the approval goes?
The condition states that a drawing must be submitted. So if the applicant does not want to go through with that and submit a drawing, they would need to, the condition would need to be amended to either state that building code is satisfied or that the condition would be removed. But the condition currently cannot be cleared unless a drawing is submitted.
Members of the panel, Mr. Vervoort, Mr. Otto, any comments, questions?
It seems to me that the condition regarding the limiting distance wouldn't be that hard to fulfill if you just provided a sketch. So I'm not sure that's worth a hill to die on. I agree that given the size of the lot, it may be appropriate to have a larger building envelope. I just had a question for planning regarding the phase 1 environmental assessment. I understand an aquifer report has already, a hydro-G report has already been prepared. Is that correct?
That's correct.
And there's no issues with the groundwater in that report?
The report has not yet been approved. We typically review those reports after the decision is rendered. So I cannot confirm whether the report is sufficient at this time.
Okay. And do we know if a phase 1 environmental site assessment was required when the existing house was built back in 2011?
I do not know if that was required then.
Okay, because I'm just wondering like how much that's going to add other than costs to the applicant. I'm not sure that I know that it's policy when there's an old discontinued landfill site in the area, but I'm just wondering if we have a satisfactory hydro-G report if a phase 1 is required. Do you have any comment on that?
I can say that building code doesn't require an ESA. So since this is a different type of application, that's why it's being triggered at this point instead of when the house was constructed. Whether hydro-G may not necessarily fully clear the need for an ESA. There could be other issues involved. But the hydro-G findings may assist in the ESA determination.
So if we added the wording if required to the ESA condition, would that make sense? I think
that could be that would work. Yeah.
Thank you.
Any comments, Mr. Otto?
Yes, the only comment I have is in your proposal, you mentioned there was a horse boarding facility within a certain distance. How close is that distance? Because you may require minimum distance separation.
Yes, and I can't give you an exact distance at this time, but it is an adjoining property to the south, and we will work with staff if we need to provide that.
Any final comments, Mr. Johnson?
Yes, Mr. Chair, just I agree. There's no hills to die on here. We would like to work with staff and the company that's doing the EIS to define a larger envelope. So as long as staff is open to discussing that, we're happy with that. In terms of the limiting distance, we do have to do a survey, we do have to do a drawing, so we will identify the distances to the west property line. So we're not concerned, sir. So no, I believe we're happy.
Okay. Members, could we pass this with that one change that you made, Mr. Vervoort, that planning was agreeable to? Yeah. Okay, it's passed. Thank you.
Thank you.
Next item is 4639 Highway 17, and I think it's remote. Am I right? Tracy Zander and Harvey and Gail Hill.
Mr. Chair, I believe the applicant is connected online. We're bringing them forward.
Okay, I see Tracy Zander.
Good morning, Mr. Chair, committee
Hello.
members.
Good morning.
I'm not sure if my
You're on
clients are joining. Excuse me, I'm Tracy Zander from Zander Plan. I'm the
I
agent.
can't hear you. I think you're on mute. Could you turn on your microphone, please?
Can you hear me now? Are you able to hear me, Mr. Chair?
Is there an issue at our end on that?
Maybe, Mr. Chair, we're just investigating that at the moment.
Okay, we'll check it
Apologies.
out.
Are you able to hear me now?
And
Can you hear me now? No.
let's have a test. Maybe we can hear you now. Ms. Zander. Mr. and Mrs. Hill. Can you hear me?
I can hear you. Can you hear me, Mr. Chair?
Raise your hand if you can hear me. Okay. I can't hear you yet.
You cannot hear me. Are you able to hear me?
I can hear you.
Oh, Mr. Hill, you can hear me?
Yep.
Oh, interesting.
I can hear now.
Okay.
Okay, we're on.
Very good. Thank you, Mr. Chair. I'm Tracy Zander from Zander Plan. I am the agent for the property owners, and I believe Mr. Hill is here as well.
Yes, I can see you all. Okay, would you like to make any comments that you have, Ms. Zander?
Thank you, Mr. Chair. I'm happy to describe the application if you wish, but we have reviewed the staff comments. They don't appear to have any concerns, and we have discussed the conditions that are recommended and don't have any concerns. So I'm in your hands if you would like more details or not.
We have read what you have filed.
Okay.
So I think we have that. We don't need anything further unless you had something further, Mr. Hill. Do you have anything that you wish to add?
No, if everything's approved, that's fine.
Okay. Any comments from planning? Anything to add or changes?
Thank you, Chair. Through you, we have no further concerns with the requested conditions. Staff are satisfied with the proposal.
Okay. Members of the panel, Mr. Vervoort,
No comments, questions or concerns. Thank you.
Mr. Otto.
No comments, questions, or concerns. Thank you.
Okay. Thank you very much. I think we could pass this. Are you agreeable to this? Okay, it's passed. Thank you very much. Ms.
Thank you.
Mr. Hill, thank you.
Thank you very much.
Okay, we got next item, 2587 Birchgrove. Mr. Bolduc.
Good morning, Mr. Chair.
Good morning.
Would you like me to go through a brief presentation?
Briefly, if you could, we have read everything, but
Okay.
if you could just briefly hit some of the points that you think are important, that would be of assistance.
Sure thing. I do have a full presentation, but I don't have to go through all the slides. But if you
No.
could skip to the main slide showing the consent, I think it's slide 2 or 3. Essentially, it's a rural lot. I will note on this slide here that the entire lot is located within a floodplain. The purpose of the application is to construct 2 buildings related to the operations of an agroforestry operation, essentially a tree farm. There's an agricultural storage building, which is used for the storage, drying, processing, and other such activities. And then we've also amended the application to include, thank you, a grain silo with a particular size in order to facilitate the development of both buildings at the same time.
Okay.
We've noted the concerns from staff, but we've also noted that the RVCA have no such concerns and that a permit from the Conservation Authority will be required.
Planning, any comments?
Thank you, Chair. So our only concerns here were that the structures may not actually be regulated by Section 58 of the zoning bylaw because they are an agroforestry operation. So as such, they're permitted in the zone as is. Our main concerns were whether or not they would have any impact on the floodplain, which the RVCA would be commenting on. So.
Members of the panel, any questions? Mr. Vervoort?
I'm just trying to understand, so the lot in question is 2.2 hectares, is that correct?
I believe so, yes.
And then, how is this going to work? Is there other land for the tree farm, or? I'm trying to understand this operation.
So it's quite a sizable lot, and most of the agricultural activity is going to take place at the rear, although there's a small portion at the front. The total lot coverage is in the area of about 3.7%. So we're not too concerned over the stormwater concerns. And again, the RVCA has issued no comments or no concerns.
And then how does the grain silo tie into this? I'm trying to understand.
The grain silo is requested based on the future expansion of the operations and for the storage of materials and not necessarily, but it could be grain or other side projects effectively with respect to the agricultural operation.
Okay, thank you.
Mr. Otto?
Yes, if you could, a little more detail. Have you currently got trees or anything planted there, or what type of trees are you planning on growing? Because it does seem to be a lot of building for a relatively small acreage of trees.
Yep. So we did provide a report prepared by the owner. So this will be the owner of the future farm currently lives in the single detached dwelling on the property. So it's a family operated farm essentially. They've started preparing for the season. I'm not an expert on this, but from what I've been able to understand is you plant the cuttings, you essentially let them grow to a certain size, then they are removed. There's a certain process for the storage over the winter months before they are reintroduced in order to get them to the correct size for market effectively. So there's multiple steps that include a significant amount of winter storage. And that's what a large portion of the agricultural storage building would be for. And then there's some processing as part of that as well. Obviously the preparation for market and ensuring that the product is available for pickup and drop off and so on. So, but to go back to your question, sorry, I forgot to answer. It's actually a willow tree farm.
So just, if I could pick up on that last question of Mr. Otto, I'm not clear what is actually stored in that fairly large building.
Mm-hmm. There were some pictures that were provided. I don't know if we can go back to the slideshow. I believe they were included. If not, perhaps I can describe it to you, but you effectively have cuttings that grow to quite a substantial size. There we are. So you can see that there's the harvesting stage, the drying stage, and then the storage and stacking stage. These are images that are not taken by my client because the farm's not up and running, but this is the sketch that they provided showing the different areas of the barn, including the harvesting, drying, and storage and stacking different stages. So you can see that they're quite long. I believe they grow all the way up to about 18 feet. And then you would stack them on pallets, which requires a certain amount of height. It's quite a sizable operation, but a lot of it has to do with, I said, the temporary storage in the winter months where you have to bring them in, bring them back out. It takes quite a bit of room.
Are these trees growing on your client's land?
Correct. They are grown on the property. My understanding from speaking to my client is that because it's within a floodplain, it's fairly optimal conditions for growing willow trees specifically due to the humidity and the soil conditions. And so understanding that it's a great site for this type of farm, but there doesn't happen to be anywhere on the property that would allow for a building to be developed and not in a floodplain, then this was the next best option to select the site within the 100-year flood line away from any potential concerns.
So when you say some of the trees stored are 18 feet tall, do those trees grow over one growing season or several? I presume.
My understanding, it depends on what stage the client or I guess the purchaser of the product wishes for that tree. You can get small trees, more mature trees essentially. But my understanding would be that they they would prepare different products, and some products require a little more time, a little more storage, and therefore a little more room.
Any other questions or comments from planning at all? Members, Mr. Otto?
Yeah, I just have a follow-up. I was a little shocked when you said willows, and I was trying to figure out in my head what they would be used for. But this could be like willows are a fairly well-known tree in regards to aspirin. I believe there's a drug in them that is used in the manufacture of that, and also it could be used for willow tree manufacturing of furniture and stuff like that. Could you explain what they're going to use this end product for? Because I find it interesting, and I was the more I listen to it, the more I'm in favor of the application. So just a little more clarification if possible.
Yeah, absolutely. So my understanding is that the end product is going to be the trees themselves. They're not looking to refine the trees into lumber for manufacturing or anything like that. It's a tree farm for the purposes of providing ready to plant trees for your property. So if you wanted to purchase, I know, for example, at my family cottage, we have a couple willow trees, and those were purchased, brought in, planted, and they've been thriving. So the end product is the tree itself.
Hello, panel and chair. May I provide a few comments? I am Sal Piamonte, the owner of 2857 Birchgrove Road.
Yes, go ahead.
Good morning.
Morning.
I just wanted to maybe shed a bit more light. Jacob's done a great job of trying to of explaining what we're doing. I think there's a little confusion when it comes to willows, because you're right. There are many uses, and for us, the whole idea is about sustainable agriculture. Willows, what we're growing is not necessarily the willow tree, as you see, like the big weeping willows. We're growing cuttings. So they are perennials. They come up every year. And they have multiple uses. There are multiple markets, which we've sort of tried to outline in our report. So willows are also used in soil detoxification techniques and soil erosion techniques because of their extensive root systems. So there's a lot of municipalities, NCC, that you'll see them planting them in various areas where there's soil erosion taking place. Many instances, investors will purchase land that, let's say, has some impurities in it. So they know they have X amount of years before they're going to move forward with building applications. Sometimes what they'll do is they'll plant a field full of willows, and willows are very effective at pulling impurities out of the soil. So they grow really quickly. So to give you an example, we just finished planting 5,000 cuttings. They're about 8 inches each on our property. We have 20 different varieties of willows that we've planted. This is all based on a year's worth of research and visiting farms, speaking to people all over North America and Europe about it. And they're harvested at the end of winter near February. So basically what you're seeing is a plant go from 8 inches to anywhere from 9 to 18 feet tall by the time we cut them down. And the reason why we need the space is because they are so large, and the process to sort them and to dry them, they have to be dried standing up and air dried. They can't be touching each other. It's really, it's just a lot of space. And so they also keep. So let's say for some reason, certain varieties aren't sold 100% during one season. Well, they're stored to be sold for the next one. They won't go bad type thing. So that's part of the reason why too, we are also looking at the additional storage, is because they take up so much space. So you have various markets that you're selling to. There's, floral and landscape, people that want winter gardens. They're used for windbreaks, land erosion, soil detoxification. And I apologize for going on. I just wanted to sort of speak to the sustainability aspect and what we're doing here in our little farm.
Okay, thank you. Any questions of this gentleman?
No questions for Mr. Piamonte. I just had a quick question for Mr. Tieft. So my understanding is that the only concern really from planning is regarding the water runoff from the building, and that The Conservation Authority hasn't expressed concerns with respect to that?
That is correct.
Thank you.
The other concern from your report was that these are not minor variances.
That is also correct.
Yes, okay. Mr. Otto, anything further? No, I'm fine. Okay. Anything further, Mr. Verwoerd? What are your views on proceeding?
In favor of the conditions.
Are you in favor of the conditions? Thank
I
you.
believe there were only two comments and one was related to a grading plan at the time of building permit. And I don't recall the second comment off the top of my head. But we had no issues when we went through them, no.
Okay, we'll make a decision then. We'll approve it.
That's great. Thank you very much.
Now we have Dobson, items 4 and 5. Yeah, and I note that Mr. Vervoort has declaration of interest on this item, and he'll be leaving us. Thank you, Mr. Vervoort.
Mr. Chair, I would just note that staff have just received the sign posting declarations for these applications.
Okay, so we don't need to. Okay,
Thank you, Mr. Chair.
who'd like to go first?
Good morning, Mr. Chair. For the record, I'm Rich Chown, Director of Planning and Development for Novotech. I'm joined this morning by my colleague, Adam Thompson, project manager. Thank you. Sorry, I'll start over again so it's recorded properly. Thank you, Mr. Secretary Treasurer. For the record, Murray Chown, Director of Planning and Development from Novotech. With me, my colleague Adam Thompson, also a planner with Novotech, and I'm joined this morning by Roberto Alberto, a partner at Gowlings. Mr. Chair, it's early in your tenure and looking forward to appearing before you over the years ahead. We're here this morning on a procedural matter initially. We are firmly of the opinion that the applications that we have filed with the committee were filed well in advance of the minister's approval of the new City of Ottawa official plan, and that the clergy principle should apply, and that the committee should review the applications under the policy framework of the 2003 official plan as amended. Mr. Roberto is here to present our legal argument. I'm sure you'll hear a rebuttal from staff who don't agree with our position. And then I'd welcome the opportunity to provide some summary comments. And I'll turn things over to Mr. Roberto. Thank you.
Okay, thank you.
Yeah, so I'll focus on the clergy principle. I think it's really a threshold issue, and once that point is determined, I think things will flow from there. The committee should have before it 3 letters, 2 from Gowlings and 1 from Mr. Schramm in the city's legal department.
We've read those.
Perfect. And our emphasis today is I'll briefly review the clergy principle, and we have a slideshow that I think would be helpful if it comes up to slide 2. And why the clergy principle applies on the date that the application was received, being September 22nd, 2022. And so I'm not going to read the slides, but I think it's a helpful summary and a quick reference for you folks about the clergy being a longstanding doctrine applied in the land use planning context, wherein the policies are to be evaluated on the basis of the laws and policies as existed on the date the applications were made. And so there's some of the key quotes from the clergy matter, which was upheld by the Divisional Court and the Court of Appeals, still current law. And we've provided a book of authority that shows it's still current law. But essentially, fairness is dictating the policies are not to be a moving target. It's notable in the city's letter, and if we go to the 3rd slide, the city's indicated that they're in agreement with the statement from James Dick construction case. Sorry, I think we've gone back one, please. From the James Dick construction case, about the policies being applied on the date the application was made. So that's where we're having our fundamental disagreement, although the city has another argument that I don't understand how it reconciles with that, but I'll deal with that very briefly at the end. We've also included section 45.4, but again, it's all about when was the application made. And again, the policies are not to be a moving target. So if we go to the 5th slide. So this is the chronology. It's included in our second letter. And so that first submission in July 15, 2022, that contained an EIS from April. And then the second submission is really the key. It's the sketches, and there's been no changes to the sketches in terms of the layout of the severances since that time. That was when this application was made. If we go to the next slide, there's some further correspondence in November. These changes are de minimis. They are very, it's adding numbers to an application form. It's adding additional details to the slides, to the sketches. And so again, very, very minimal changes. The city advances a number of arguments, but essentially November 4th is the key date. That's when the OP was approved by the minister. And so the city's position is essentially November 7th hits, and then you got to start all over again. You need to do a new EIS. You need to restart your application. And so it's essentially that the policies are a moving target. The city's argued, firstly, that clergy does not apply even if the materials were submitted on July 14th, but it says in its letter it's not necessary to fully articulate that argument. And we invited an invitation for that, and there was no response. I would suggest that that's an invitation to suggest that clergy is dead, and there's no law to support that. For November 9th, which is the other date that they state, if we go to the next slide, it's Mr. Thompson's email. It just shows he's just re-providing materials. There's nothing new there, absolutely nothing. No changes to any sketches on November 9th, nothing. November 7th, a couple changes to some details. So I think, if I may, I have one last point. I know my 5 minutes are up, Mr. Chair, but if go ahead. Yeah. The city also argues in their letter that former Chair Krushelnicki and James Dick found that the city deeming an application complete was the standard by which to apply clergy. If we go to the next slide, I've included the paragraphs from the James Dick decision where the board rejected an argument that stating an application was deficient after receipt did not justify overcoming clergy. So I would suggest that the board actually rejected the argument, and the city has sort of taken the argument advanced by the town in that case. So in conclusion, we submit that clergy applies. The application was received on September 22nd, and so the 2003 OP should be applied. Thank you. Those are my submissions.
Okay, thank you. Do you want to add anything, Mr. Chair?
Sure. Just one quick additional comment that I'd make, and I'd refer the chair and the members to page 6 in the book of authorities that were provided to the committee last week. And I'll just read the paragraph 9 on page 6. This is the decision, the original clergy decision on page 6 states, it was agreed that the subject applications were first filed in July 1989. Although the applications were revised in 1994 to reflect evolving official plan amendment number 238, of which more will be said later, they remain substantially the same as the 1989 versions. The applications were again revised in 1996 with respect to a church site on the lands at the request of the city of Mississauga, but did not alter the applications in a manner that could be considered as substantial. As a result, the board finds that the date of the applications is July 1989. And so with respect to my colleagues at the City of Ottawa, I'm firmly of the opinion that the application date for these applications is September the 22nd. What transpired since then did not in any way alter the size, the shape, or the location of the lots that are being requested through these applications. The applications were made on September the 22nd. The clergy principle should apply, And we should be considering these applications under the 2003 plan. Thank you very much.
Mr. Thompson, do you want to add anything at this point in time? No, okay. Planning comments, please.
Thank you, Mr. Chair. Just to confirm, would you like me just to comment on which official plan the department is applying at this time?
Yes,
Thank you.
please.
So the City Legal Services has had an opportunity to look into this and review all the letters and actually discuss with the consultants, legal counsel as well too. And we are firmly of the opinion that the new official plan does apply. And this is largely to the fact that the application was not submitted on September 22nd. Part of an application was submitted. The application forms were incorrect. They were not correctly reflected. Part of an application was submitted, and this is absolutely what our City Legal Services has confirmed at this time. So we will be applying the new official plan. And I would just like to note as well too, that if we were just to apply the September 22nd date, we would still have to deal with the City Council transition policy, which is stated that if an application is deemed complete after City Council has approved the new official plan, but before the minister has approved it, City Council may apply, City staff may apply whichever provisions are more restrictive between the new official plan and the old official plan. In this case, there are numerous provisions that are more restrictive within the new official plan. So regardless of which date applies, and I do want to make 100% clear, we are determined, we are clear and concise that the new official plan applies based on the first, the committee's deemed complete date, which is December 14th. But if we go back to when the last submission materials were received, it would be November 7th was the last proper submission material. But just wanted to note the transition policy as well too, which has been approved by City Council as well.
Okay. Mr. Otto, do you have any comments, questions? Okay. I think we have a couple of people by remote. Drew Palisi and Janet Clark and Peter Blanchet. Are they with us, staff?
Mr. Chair, Drew is a consultant working for us who is here to or is online to participate in the event that you were to decide in favor of our position and then actually chose to proceed with the applications, and he would be commenting on any concerns or comments with respect to the EIS that was filed with the committee. I'm not sure who the other individual is.
Janet Clark and Peter Blanchet. Are they were to come in by remote? I don't see anything on my screen.
Mr. Chair, they're not online.
They're not online. Okay. Okay, thank you. I have questions to Mr. Alberto. A clergy principle. I understand what that is. But it doesn't say that the new OP is not in effect. Even if we say, let's just use this, that your clients filed before the new OP came into effect. And I know that's an issue, but let's just use it, okay? Even if that is the case, the clergy principle, as I understand it, and I've asked for your comments in a minute, doesn't say that the new OP doesn't apply. It's only the new OP doesn't apply if there's something in the new OP that would basically make your clients, make the applicant have to go back and sort of redo the whole process again, you know? I don't see any evidence of that. And the second thing, when I looked at the Novatech report, it refers to the new OP throughout. And the argument is that everything applies based on the Novatech report. So I don't see any evidence that there's anything more restrictive in the new OP than in the old OP that would make you folks have to go back to square one and do this all again. You know what I mean?
Yeah, in terms of the impacts of that, I think Mr. Chow's.
Yeah, okay, that's fine. That's fine. Thank you.
So thank you, Mr. Chair. Off the top of my head, I can think of two provisions of the new official plan that are more difficult for us to deal with. One's impossible for us to deal with, quite frankly. One of the provisions of the new official plan is that the proposed lots must have frontage on an existing open road allowance. That was not the case in the previous official plan. This panel of the Committee of Adjustment over the years has approved numerous severances on lots that actually didn't have frontage on an open maintained public road, subject to the condition that the road would be extended to provide access. The new official plan doesn't provide that opportunity, but is clearly something that we need in order to provide access to the proposed lot. So that's the most significant change, at least in my mind. The other significant change is the way the city's natural heritage policies are written, have greater impacts on this property than the 2003 plan. So those are certainly the two factors that are causing us a great deal of concern in terms of the applicable, which plan should be applicable. Yeah, thank you.
Yeah, on the first one that you mentioned, the lots won't be on a roadway. As I understand it, Richland Road would have to be extended. Is that correct?
That's correct. And previous panels of this committee have approved severances subject to the condition that you extend the road.
Right.
I had one person, or my team did within the last year or so.
So that wouldn't require dealing with the old OP, the 2002 OP then.
Correct. It's black and white in the new official plan. I think staff would confirm that. But in the old official plan, there was the ability to for us to apply for the creation of lots in the rural area that would have been dependent upon entering into a development agreement to extend the road.
And are you saying that we can't do that now?
Not under the new plan, you can't.
Planning staff?
Subject to staff
Sorry.
confirming that.
Yeah, sorry, I didn't want to interrupt you. Planning staff, please.
Thank you. So just to clarify, the policy that's in question right now is development within 1 kilometer of a settlement boundary. So that is the policy that has changed, which we are talking about here. Under the old official plan, there's a requirement that any development within 1 kilometer of a village boundary would not negatively impact potential future expansion of the boundary or require extension of services within the boundary itself too. So it's pretty clear within the old official plan that there has to be considerations in terms of the lot fabric, design, everything that won't limit future village expansion. In the new official plan, they added a clarifying sentence to that says it has to be on an existing road to do a severance within 1 kilometer of a village boundary. So it's not an entirely new policy. It's just a clarification and more restrictive policy. Just because if we are doing development within 1 kilometer of the settlement area, we do need to be mindful of how future roads that are going in and how that could impact that potential settlement expansion.
Right, so if that, excuse me, if that's the case, if there's a condition that the severances be granted depending on Richland Road being installed, I take it at the cost of the applicant, or is that a problem then from planning department?
So there is already a condition that does require Richland Road to be extended and constructed to an in-service point.
Yes.
The issue right now is constructing the road right now without a comprehensive review, something more in-depth than a severance application, will negatively impact potential future village expansion at this time. So that is already in the old official plan. Within the new official plan, it just is more restrictive, saying that we don't want any new roads constructed within 1 kilometer for a severance of a village or settlement area, because that will negatively impact it. So it's a clarification, more restrictive policy. The issue is the road has to already exist for a severance within 1 kilometer of a village, not the construct a future road.
Okay, so what you're saying is that under the new OP, that's the 2002 OP, the severance can't be granted because the road doesn't exist yet.
Under the new official plan, the 2021, yes.
Yes. And under the old OP, the 2003, the severance could have been granted, even though the road didn't exist.
If it can, just this one policy, everything else everything else equal, just looking at this one policy, it's still not clear that it would be granted under the old official plan because they would have to demonstrate that the road network that is being created will not negatively impact the village boundary.
Right. Okay. On the second point that was made about the natural heritage, I wasn't really understanding that. Are you able to comment on that, please?
Yes, so they did make a comment that a new EIS would have to be created under the new official plan. That is incorrect. They've already done a lot of their field data and testing. It's just the conclusions would have to be more robust. So they can absolutely use the existing environmental impact statement. It would just need to be updated and have a little bit more rationale and conclusions with it. Just to demonstrate the features that are there. And just to be clear, those environmental features, they already exist, whether it's under the new official plan or the old official plan, those features are there today, and we have to respect that. Under the old official plan, it just demonstrates, you need to demonstrate no negative impacts to the ecological features or functions. Under the new official plan, it's more restrictive, and because the amount of features that are in this area, the classification for or the environmental protection policies for this area have been increased in the new official plan to reflect the features that exist there today. So the new official plan requires that at a minimum they maintain the ecological functions or features and wherever possible enhance them. So it's not just the no negative impacts, there needs to be a maintenance and enhancement, and it can't compromise the long-term restoration efforts of that.
Right. Mr. Otto, have you any questions or comments?
I guess a comment in regards to if this was granted, provision upon the road being built to the city standards, et cetera, et cetera, et cetera. Is there a possibility that the city would not grant permission for that road to be built at all?
Thank you. Through you, Mr. Chair, that is something that it would be a new application. It would be a road opening application, and it would have to go through the standard procedures at that point. So as part of the road application, they would need to do an updated EIS, and that would be under the new official plan. And again, they would have to adhere to those policies at that time. I can't say that we would refuse it or approve it at this time. It would be part of a more comprehensive review in terms of the engineering documents, the potential impacts, how much would have to be cleared. So it would be reviewed in greater capacity at that time, but it is not a guaranteed yes or no.
Any comments, Mr. Chan?
Thank you, Mr. Chair. So I just want to make clear that I agree with what Mr. Harrigan has told you, is that the tests to be met for the EIS under the new OP are more rigorous than the tests under the old OP. And to the member's question about the road and getting an approval for that road, that is a process we would have to go through within the 2 years, a 2-year period within which we have to clear conditions for the severances to proceed. So we know that there's work ahead of us if the committee was to approve the applications that which may in the end be insurmountable, but we're prepared to, the first step is to get a decision with the conditions attached to it, and then we'll go to the next step. And as I said, Mr. Chair, if you're prepared to decide in our favor today, then we're prepared to proceed with a presentation on the application under the policies of the 2003 official plan. If you want to reserve on the discussion about the applicability of clergy, then obviously we'll make a decision on our next steps once we get your decision. So thank you very much.
Yeah. Mr. Alberto, do you have anything you wish to add, sir?
Nothing to add.
No? And Mr. Thompson, everything's there? Okay. Any further questions or comments from the planning department?
Through you, Mr. Chair, no questions, comments about which official plan applies.
Okay. Mr. Otto, any further comments? No. Okay. I am reserved. I'm thinking we're going to reserve. Yeah.
Mr. Chair, just on a matter of procedure, I just want to highlight that the Committee of Adjustment doesn't issue advance opinions or make advance rulings. This hearing is really an opportunity to hear all the evidence on both the arguments regarding the applicability of the clergy principle, but also the evidence on the merits of the application. And so I'm just want to be clear that there's no tradition of breaking down those two steps. There's just a single hearing. And the committee will be making its findings on all of these issues in its written decision.
Thank you very much for that. I appreciate that. So if you
Mr.
have,
Chair, I think that presents some difficulty for us. Because until we know which plan we're speaking to, our evidence is different and the staff response will be different. So just like with all due respect to the Secretary Treasurer, if we were appearing before the OLT or the OMB, we would get a decision on a procedural matter, and then we would proceed with the hearing. So I would understand that you want to reserve on making a decision on the procedural question. There's a lot of information here for you and Mr. Otto to consider. Once we know which official plan we're moving forward with, if you decide against us, then we have more work to do on the EIS. If you decide in favor of us, staff actually haven't reviewed our materials in the context of the 2003 official plan. So I don't, with all due respect to the Secretary Treasurer, I don't think that either side is in a position to prepare to proceed today, depending upon what decision you made on the procedural question. We're quite prepared to set the hearing on the merits down to another date if you'd like to do that.
And just to sort of add, while it may be the custom, I'm unclear what the authority is that precludes you from making a preliminary determination. Certainly, I don't see anything in section 45 that I'm familiar with that would preclude that. So, and I know that the Committee of Adjustments bylaw has not been made available despite requests over the years. So I'm not sure where the authority comes that would limit your authority to make a preliminary determination.
well, I think the practice is that we don't do that. We don't,
It could custom, but it doesn't bind you.
it isn't like in a court action where you have one legal issue that you want the judge to decide first. And then depending on that, you either go to the left or right or down the center. It's not like that. So just so I can understand though from Mr. Chown, given that he says we don't know which, the old OP or the new OP, you don't have, none of you have any further comments on this application. Is that correct?
Sorry, I didn't understand the question.
I understood from you, Mr. Chown, that without a determination by us, which we're not going to do, on whether the clergy principle applies or not, you don't have any further comments on this application.
Well, as I said, we're prepared to make a presentation on the understanding that the 2003 official plan applies, but I think that puts staff at a disadvantage because they haven't reviewed the application in the context of the 2003 official plan, or at least in particular, they haven't reviewed the EIS in the context of the 2003 official plan. So we're prepared to move forward with a presentation. Mr. Thompson's prepared to do that with respect to the applicability of the 2003 policies. If that's the will of the committee, we'll do that. But we came here prepared with the expectation that we would deal with the procedural question first.
Yeah. Planning, please.
Thank you. The planning department has reviewed the submission materials and has an opportunity, multiple colleagues from various areas within the department to review this application. And we have had an opportunity to discuss this both under the old official plan and the new official plan, and our position does not change, largely because we think the most significant issue is the provincial policy statement, which does not support this application. We are prepared to provide comments on both the old official plan and the new official plan, but I do want to be 100% clear that under City Council's guidance and their direction, we are to apply the new official plan. But for your information purposes, I would be happy to provide a few comments on the old official plan too.
But you mentioned the PPS that doesn't comply with the PPS.
It does not, no, not by our opinion.
Okay. Hey, folks, it's up to you whether you want to proceed and deal with this matter or whether we just adjourn or reserve.
I would prefer that we adjourn to a fixed date and you make a decision on our submissions today first.
Okay.
If you're prepared to do that.
No, we're not gonna, if we adjourn, it's sine die, first of all. And we're not gonna.
I'm in your hands, Mr. Chair.
Okay, well, it's not just my hands, okay? I'm
No, I
saying-
think we could agree on a fixed date.
Well, that may be, it may not be, but anyway, we can adjourn sine die and then agree on a date after. But with regard to us making a decision simply on whether the clergy principle applies in this case, we aren't going to do that.
I understand.
Okay,
Mr. Chair.
good. Okay, anything further?
I respect you in that regard. I didn't expect, as I say, there's a lot for you to consider.
Yes. Anything further?
No.
Any you want to ask?
So subject to your decision, we'll adjourn the application sine die and then we'll come back.
Adjourn sine die? Or reserve? Reserve.
Thank you.
We'll reserve it.
Looking forward to your decision, sir.
No other items to discuss, I take it? Okay, well, let's adjourn. Sorry, yes.
My apologies, just before we do adjourn, sine die is another issue. Our legal services has indicated that an application submitted under the old official plan, if it is adjourned, sine die would be reviewed under the official plan. So in this case, in the benefit, I would say a fixed date would be a better option in this case, just to maintain consistency with the application and our policies as well.
Mr. Secretary Treasurer.
And from committee staff's perspective, Mr. Chair, we would need clarity as to if you are reserving your decision, are you reserving your decision on the merits of the application? Because what you have indicated to the applicant is that you will not be issuing a separate ruling on the clergy principle or any other procedural matters. That if you do reserve, it's committee staff's expectation that you will be rendering a decision on the merits of the application. I don't believe that's what is intended in this case. What has been asked, I believe, on the part of the applicant is an adjournment to what I would concur would be a specific date to hear additional evidence on the merits of the application under both official plan versions. I would imagine is what the panel would be seeking. And so now would be, I believe, an appropriate time to determine when the parties will be able to present both those arguments and that evidence to the panel. Whether in 2 weeks or 4 weeks.
I would suggest 4 weeks. Your first hearing in August, which I think is the first. Would that be correct?
Okay, let me understand. That seems fine, but let me understand what we're doing here, just so there's no confusion, at least in my mind. Anyway, okay. We adjourn to a date. And
Tough first hearing in front of you, Mr. Chair.
well, just gets easier, right? But anyway, we will adjourn to a date then. At that date, you will come ready to present your arguments under the new OP and the old OP. Is that correct?
Sir, it will depend on your decision with respect to the applicability of clergy.
We're not going to make that decision.
Not today.
No.
But I'm hoping that you will make a decision on the procedural question. So we know which official plan we should be dealing with.
But I don't know enough evidence under the old OP and the new OP to say whether it merits the clergy principle be applied. And that's what the case law, it isn't a law that says the clergy principle. If you can show that you filed before the new OP, it doesn't mean automatically ipso facto that you're entitled to go into the old OP. The new OP may clarify some things that are actually of assistance.
But clergy clearly states if the new policy regime is more restrictive or more onerous than the policy regime that was in place on the date that the application was made, then the clergy principle gives our client the benefit of having the applications heard under the policies of the former official plan. And it's our evidence before you this morning, A, that the new official plan is more restrictive and more rigorous, and the tests are more significant than under the former official plan, and that prejudices our client. And that clergy allows you, the committee, to make a determination that you will hear the applications under the policies of the 2003 official plan. And I think we've given you that evidence in terms of what the impact is on our client. And we also have given you evidence in terms of why we believe the date of the application is September the 22nd and not November the 9th or December the 14th or whatever date the city is suggesting to you. That's not a proper application of the principles established in the clergy decisions. I think we've given you the evidence that you need to make that determination. And once you've made that determination, then we'll know how to prepare for the hearing on the merits.
And the clergy decision itself came out of a pre-hearing determination to guide the evidence at the full hearing. And again, this is a tribunal meant to be proportionate and, cost effective and efficient. So I think it's all consistent with that.
Well, I did a little bit of research myself. And I'll just leave you with this thought. It's a case of Pierce versus Uxbridge Township. 2223 Canley, 19221, Ontario LT. And it's a decision date March 7th, 2023 by K.R. Andrews in an order. And K.R. Andrews said partially at paragraph 22, as a quick summary, the tribunal notes that the clergy principle is an oft-followed discretionary principle employed by the tribunal to address the inherent unfairness of the applicants having to deal with a quote-unquote moving target, while the development proposals work through a generally vigorous and often lengthy approval process. It is commonly understood that development applications are frequently defended, while underlying municipal planning instruments may be subject to change. As a result, the clergy principle arose as a matter of procedural fairness to secure development rights that existed at the time when an application was initially submitted to a municipality. It is well understood that the clergy principle is not law, but rather a discretionary tool available to the tribunal to deal with procedural fairness issues. Now, I haven't heard that there's any procedural unfairness issues, if I could put it that way, if the new OP is used.
So sorry. The procedural unfairness is on November 7th, they say add a line to the bottom. Aha, bang on, we didn't have your application. You gotta, you're out of luck on the road policy issue. Like that it's a moving target. That's exactly the natural justice issues. November 9th, resend everything. Okay, we started all over again because we asked you to resend everything. Like that's what the natural justice procedural fairness issue is. Like the fact of the moving target, that's what clergy talks about. I don't think we've said it's absolute, or at least I
No, it's not absolute.
I haven't intended to. I don't think I've said that. But it sounds, again, there's a policy that had a greater level of discretion and then is black and white now. And the minister approves it and you add one line to the form. And because what if we said, no, we just circulated without that line? We would have been better off. We wouldn't have had a fight over this. Or if they said, hey, put everything in one email and we didn't do that, then all of a sudden it's all before November 4th and we just have their other weird arguments. But so there is a natural justice procedural. It is a moving target. It is the exact, like this is, the changes could not be any smaller to the applicant. There's no actual change to the physical application. So that moving target, that's the natural justice issue.
Okay, so that now it's focused. That's what it is, right?
Hang on.
Yep. And planning.
If I may add to add some comments to this. In terms of the moving target, we disagree that there was a moving target. We've already had the transition policy in effect and the applicants were aware of this. They does note that we may apply whichever ones are more restrictive. And that has been in effect for more than a year, and they were well aware of that transition policy. They were well aware of these new applications, the new policies and what was in place at that time. I don't believe that is a moving target. This was well aware. And then just in terms of adding that line, that really comes down to the committee's discretion, whether or not the committee staff would even circulate the application while missing that line. That's kind of the key element there. If the committee staff would not circulate the application, missing those parts, it's not a complete application. It's not a full application. It's part of an application. And that's what our city legal services has been quite clear on. I understand the applicant's frustration with that black and white change in the November 4th date. That November 4th date has to apply equally to everyone. And I get that they just missed one line, but that is significant enough to trigger the new official plan at that time.
Just to be fair, is there any reply to that? I don't
Yeah.
want to drag this.
No, the transition prevention is not an argument that was advanced by their legal counsel. And that's because you can't just have a transition provision that says clergy is gone and you can't, and nobody can look at.
No,
look at
that's
any
not
of the
what
case law, right? Like that's not.
No, it doesn't say clergy's gone. It says you can apply it or not.
Well,
Anyway,
it's up to staff can pick whatever they
Yeah,
want.
okay.
Yeah, exactly, which is not what clergy says.
okay, well, there being no further, sorry, did you want to add something? You have your hand on your microphone.
Yes, I was just going to add in terms of the application themselves too. I know we talk about adjourning this 4 weeks and then having the applicant come back prepared to address both the new official plan and the old official plan. At this time, I believe the applicant has the right to put forward their professional planning comments on which official plan applies, and just the city council does as well too, and directed our staff to apply it. So we're under clear direction from city council that we are to apply the new official plan. I can provide some comments on the old official plan, but at this point, I believe it's appropriate to move forward and they can speak to the old official plan. I can speak to the new official plan, provide some comments on the old official plan. And at that point, it is the panel members' decision on both aspects, which official plan applies and then which decision to render at that point. I don't believe adjourning it 4 weeks changes anything. There's still, as you said, you're not going to make a decision on which official plan applies. So they're still going to, in 4 weeks, put forward the position that the current official plan applies, and staff are still going to put forward the position that the new official plan applies. I don't think anything is going to change in 4 weeks.
Well, they wanted to adjourn for 4 weeks and, we want to accommodate them if we possibly can and be fair to everybody. Okay, that's it. So we're adjourned. Mr. Secretary Treasurer, is there a date that we're adjourned to?
August 1st.
August the 1st. Okay.
And I'm sorry to circle back. Will we get a decision from the committee on the clergy question?
No.
I don't understand why not. I'm sorry.
Well, I'm sorry. I thought it was clear. Why not? I thought that was part of what you said too, that you were prepared to speak to the old OP and the new OP and the differences and the difficulty that caused. I mean, a change between the OPs doesn't mean the clergy principle applies. There has to be a difficulty, but sets people back to square one. I don't know. Okay, but we would like to understand that. In fact, I thought today we would have heard that, but we have orally heard it. But when I read, over the material in the last few days, I was looking for that difference, that distinction between the old and new OP, and it wasn't there. So we aren't going to decide on the clergy principle. And I think you should come in, since it's basically 1 point on the old OP to the new OP. I don't see that's going to be that hard for you to submit on both of those. Do you?
So we can come prepared to make presentation under both official plans. Is Drew still online? I'd want to.
Yes, Drew.
Yes, I am.
Drew, if we needed to update the EIS This goes to timelines, Mr. Harrigan, obviously, because the EIS that has been prepared by Gemtech was prepared to address the policies of the 2003 official plan. If we are to come here prepared to speak to the policies of both official plans, then staff, I believe, will want to see a revised EIS before we come back, rather than a condition to submit a revised EIS. I'm sorry, I know I shouldn't be directing questions directly
Well,
to
no,
staff, but
staff
if we need to update the EIS and staff need time to review the updated EIS before we come back, it's not going to be 4 weeks. But I'm trying to remember.
Let's ask staff.
Yep.
Thank you. To answer your question, I believe the environmental impact statement could be updated as a condition of approval. They've already done the field testing, the data. We have all of that information there. The difference is no negative impacts versus maintain and restoration. And that's just the end conclusion at that point. At this point, it could be revised as an updated, as part of a condition at that point, because we do have the data and the field tests were done at that point. So we have the raw data. It's just interpretation and conclusions that are drawn from that. So at this point, I believe we could proceed in 4 weeks without a full revised EIS and just do it as a condition of approval. Ideally, we would like to have it in advance because I believe it would make for a better discussion, but I don't believe it is a requirement.
Okay, okay, everybody's good, same page. We're adjourned.
Thank you, sir.
Thank you. The meeting is adjourned. You folks adjourned to August the 1st, okay?